Next case is case number 181437, and it is, I believe you pronounce it OPYOKE, is that correct?
OPYOKE.
I'm sorry?
OPYOKE.
OPYOKE, okay, thank you. Susan OPYOKE versus John Parrish OPYOKE. And is 5 minutes good?
That's fine, thank you.
Okay. You may begin.
May it please the court, I'm David Manning. I'm here representing the appellant, Mrs. OPYOKE. Mr. Solomon is representing the appellee, Dr. OPYOKE. This case had its origin some time ago. Actually, the parties were married on September the 20th of 1997. And what happened was there was a judgment initially entered on this case on February the 26th of 2018. That judgment did not embrace all of the issues that had been presented to the court, and therefore on May 31st of 2018, a supplemental final judgment was entered. Timely notices of appeal were filed with respect to each of the judgments, and this court entered an order of consolidation so that the issue presented today, I might first tell you, is the issue of valuation of the personal goodwill of the husband, Dr. OPYOKE. We had originally made another point on this appeal, and the other point had to do with the unequal distribution of the equitable distribution. But since that time, Dr. OPYOKE, his counsel, and I have been able to resolve the issue of alimony. Alimony is no longer an issue in the case. The only issue today is the issue involving the equitable distribution of the asset consisting of the urgent care center. I'd like to read to you, if I may, what an urgent care center is. That's, strangely enough, that's a statutorily defined entity.
Let me go back to something for a second. There were two other points raised in the brief.
Yes, sir.
That you say have since been resolved.
The issue of alimony, and that's correct, that's over with.
When were those resolved?
I think last week, Your Honor.
Okay.
So the only issue we have today is going to be the issue of the calculation of the value of the goodwill, and we're going to talk about whether or not it's fair market value of certain parts of the goodwill and fair market value of the business, but we'll be talking about the concept of goodwill today. May it please the court. I'll start then by telling you that this has to do with an urgent care, two urgent care centers. These urgent care centers were clearly organized during the marriage. They were clearly the product of marital labor. There was two couples involved, Dr. OPYOKE and his wife, and Dr. Duick and his wife. And the two couples met together, the four of them. They decided that they were going to form these urgent cares, and they worked hard to do it. They decided they would form an LLC that would be the operating entity. And I might add, the LLC was in accord with exactly what the statutory definition would say. Statutory definition of an urgent care center is an urgent care center means a facility or a clinic that provides immediate but not emergent ambulatory medical care to patients. And it goes on further to say that what's distinctive about this, they do not require a patient to make an appointment and is presented to the general public in any manner as a facility with immediate but not emergent medical care provided. In other words, this is a location entity. It is emergency care.
And that's what one of the experts testified to.
Yes, ma'am.
But it seems like the trial court rejected that this was all about location. And so why should we not defer to the trial court's finding in that respect?
Well, you could. You really could. I will tell you that. But instead of focusing on what the trial court has done here, I want to point out the error that was made with respect to the teachings of both Thompson and Held and Schmidt and Soriano, which are the four cases that I cited in this case, on what is the first responsibility of the trial court. First thing the trial court must do is listen to testimony to determine whether or not there was any goodwill at all in connection with the operation of these two centers.
Well, actually, isn't it more specific than that? It's either personal goodwill or enterprise goodwill.
Yes, sir. And first step one is to establish whether or not there is any goodwill at all in connection. It's conceivable that there would be a business operating with a negative net worth. So what Thompson teaches us is the first thing you do is take a look at the business. You determine the fair market value of the business. Then you determine whether or not there is any goodwill at all. And the way you do that is to decide whether or not the value of the business is thus established is greater than the net asset value of the business. If the goodwill of the business is greater than the net asset value of the business, then what we try to do next under Thompson and under the other three cases I've cited is make a determination of what part of that is personal goodwill and what part of that is enterprise goodwill.
And wasn't the evidence in this case that the appellee, I guess, specialized in providing occupational health services for, I think specifically for the firefighters in the area? And there was testimony, I believe, that when you say location, this doctor, the different firefighting, the workforce would come to him even though his place of business may have not have been the closest place to receive that type of care geographically. So they would go past other locations that would provide the same medical services and go exclusively to his practice for, I guess, arguably they're taking the position because it was his bedside manner, his personal connection with his clients to continue that business. Was that evidence that was at least in some respect presented to the trial court?
I'd like to address that particularly because that's a second part of the argument. The question that you're really propounding is, to what extent was the goodwill associated with the occupational practice a part of the court's responsibility in valuing goodwill in this case? And both experts agreed that only 12% of the gross revenue of this business was attributable to the occupational services treatment. Now, number one, it wasn't so much that they came to Dr. OPYOKE. It might add that for purposes of advertising, Dr. OPYOKE's name never appeared in any advertisement. Dr. OPYOKE's name never appeared on any of the gadgets that these parties developed in order to develop the business. What happened was that the expert that was called for Dr. OPYOKE testified that when I asked him the question, did you calculate the value of the personal goodwill? His response was no. Later on, he tried to explain to me why it was that his response was no. And he said something astonishing. He said, well, 12% of the revenue is associated with the occupational business. I know that Mr. Mays, who's not an employee of the corporation, he was just a general contractor of the corporation. Mr. Mays was the one that determined where the goodwill would go. Mr. Mays determined where the patients for the occupational services would go. Mr. Mays testified that if Dr. OPYOKE left the business, he would see to it that Dr. OPYOKE would receive the occupational services patients. Now we're talking about 12%. But we still haven't done the thing that Thompson teaches is the first thing that must be done in connection with the valuation of the goodwill of the business. The first thing you do is if there is goodwill in the business, you will value the personal goodwill. Now, ask yourself this question, and I've dealt with this in my brief, in part 2 of the brief. How is it that if you take away the 12% gross revenue, you actually diminish the fair market value of the corporation by more than the gross revenue? There was never a satisfactory answer to that question. The expert for Dr. OPYOKE testified it was a mystery. Well, it's not.
There was competing testimony on those issues. So aren't you asking this court to reweigh the evidence?
No, ma'am, I'm not. I certainly am not. There was no competing testimony. Mr. Tondreau, I'll call him by name, was the expert who testified on behalf of Dr. OPYOKE. Mr. Tondreau said he did not do step 2 of the Thompson directive. The Supreme Court in Thompson teaches the first thing you do is you determine whether or not there's goodwill. If there's goodwill...
Doesn't this court require specifically that an expert in evaluating enterprise goodwill only use a fair market value approach?
We are required by Thompson to find out fair market value applies to the gross value of the business. Once you find out what is the gross value of the business, the next thing you do is you adjust the gross value by the net asset value of the business.
And it's on the proponent of the party that is asking the court to accept that there's enterprise goodwill to establish that value, right?
Absolutely. No.
And so we focused on the expert presented by the former husband, but what about Ms. Opioke's expert? He also did not use a fair market value approach.
Ms. Opioke's expert witness, Mr. Lewis, testified very clearly, unequivocally, that in this particular case, it was all enterprise goodwill.
He testified to that
Yes, ma'am.
point, but the method that he used in getting there was an income approach, not a fair market value
Well,
approach, right?
that's not, that, if I may be so bold as to correct the analysis of the court, both of the experts agreed that the capitalization of income was an appropriate way to take the first step, the fair market value of the business. And that's what they did. First step.
That's what I'm asking. They might have agreed to that, but this court has said that the only way to do it is to see a recent actual sale of a similarly situated professional practice, an offer to purchase such a practice, or expert testimony and testimony of the members of subject profession and a similar practice in the relevant geographical and professional market. That's what was that present here?
Yes,
of a similar practice.
That was done because Mr. Lewis testified that in his experience with the urgent care centers, it was all a matter of location. Do you realize one of the things that Mr. Lewis pointed out that you don't see mentioned in the brief in this particular case of Dr. Opioke is that there were 9 and 11 other doctors who were providing the care to the patients who would present themselves for treatment at the urgent care center. When you have 9 to 11 doctors, no one of which was coming to Dr. Opioke, there was not one jot of testimony that any single patient went to the urgent care center because of the professional reputation of Dr. Opioke. That's why Mr. Lewis, to answer your previous question, that's why Mr. Lewis said this is an urgent care center, for heaven's sake. And when you go to an urgent care center, you don't go for a particular doctor. You go because you've had an emergency. And you go to the urgent care center to get the treatment. Now, under those circumstances, we have to ask ourselves, how are we going to apply Thompson? Thompson, fair market value of the business. Nobody disagreed with that. Thompson, how much goodwill was there? Nobody disagreed with that. Thus, the very next question I asked Mr. Tondreau, did you calculate the value of the personal goodwill? Answer, no. Why? Because earlier in testimony, he had heard Dr. Duick say that in the event that Dr. Opioke had to leave the business, no one ever said he did, but that's what he said, I'd go with him. Thereupon, Mr. Tondreau said, well, if Dr. Duick would go with Dr. Opioke, then there's no value whatever to the business. The goodwill all evaporated. Now that shows a fundamental misunderstanding by Mr. Tondreau of what his responsibilities were as an expert witness. Keep in mind, this is the man, Mr. Tondreau, who said in response to my question, do you know what an LLC is? He did not know it was a corporation. Mr. Tondreau had, I don't want to comment too much on him because that is a matter within the discretion of the judge, but what is not within the matter of the discretion of the judge was the methodology employed by Mr. Tondreau in connection with his determination of the personal goodwill of the company. He didn't do step one. And the reason he didn't do step one is because he erroneously listened to the testimony of Dr. Duick that he would go with Dr. Opioke across the street to compete if that would happen because he didn't want to practice with anybody else. Wait a minute. That's not what the teaching of Soriano, the most recent case I cited, is all about. That's not what they said. Instead, Your Honor, they were quoting right from what you just said. That was the responsibility that Mr. Tondreau had. He didn't do step one, step two, actually. He didn't calculate personal goodwill. Now, that's where the difference between the parties lay. Now, is
the fact that there was no non-compete agreement, does that in any way affect the valuation of this company?
It could. It could, and it was given due consideration. That's the second point that was raised.
Isn't it common to have? I think there was at least some testimony that it's common to have in these type of businesses some type of non-compete agreement.
Mr. Lewis, the expert for Mrs. Opioke, even testified that he would think it was a matter of poor business practice not to have a non-compete covenant in this type of business practice. And that certainly comes within the language of the case, and it was Thompson, not Thompson, but it was in the next case, Schmidt case. In the Schmidt case, it says a non-compete covenant is a signal of personal goodwill. And of course, that's what Mr. Lewis recognized that it was. And then he went ahead and explained in this case why, even though it was good practice to have a non-compete covenant, it does not, in the inquiry of a court with respect to the presence or the value of the personal goodwill. I think that's what the argument was really being made with respect to this oddball situation of the transfer of personal goodwill of Mr. Mays to Dr. OPYOKE by virtue of Mr. Mays' selection of Dr. OPYOKE as the person with whom he would go if Dr. OPYOKE had to leave. Now, you look puzzled when I say that. I'm puzzled too, because there's no case in Florida which says that the general contractor with a business who has goodwill with respect to his subset of customers can transfer that goodwill to someone else who's moving away as a result of a measure of the value of the personal goodwill of that person. Now that's what part of the problem in this case has been, is the two fundamental errors that were made by the expert witness. This has, if I may say so, Your Honor, it has nothing to do with the competing testimony of the expert witnesses. Clearly, a trial judge can select the competing testimony, but the responsibility of this court is to determine whether or not the testimony of Mr. Tondreau was competent and therefore sufficient to support the determination made by Mr. Tondreau that there was no personal goodwill.
And counsel, you're in your rebuttal time. Just wanted to let you know.
Thank you, Your Honor.
Okay.
I think I would just like to say one thing. The error in this case is twofold. Mr. Tondreau made a mistake when he said that the transfer, his first mistake was to say, I never calculated the value of personal goodwill, notwithstanding the specific instructions of the four cases to which I have alluded in my brief. Next, he then wanted to go ahead and try to help himself out without to say, but in any event, I calculated the 12% value of the business, the loss of that 12% value, to result in a loss of all the goodwill. And in doing so, he compared that loss of 12% to the goodwill of $800,000 that had already been determined. Thank you.
Good morning. May it please the court. My name is Sandy Solomon, and I represent Dr. OPYOKE. There are three reasons why the trial judge found that there was no value to be divided as part of the marital estate above the net adjusted book value of $106,802. Suncoast Urgent Care Centers was owned 50-50 by two friends, two colleagues, who had been working together since 2002. They had no operating agreement, no bylaws, no management agreement, no employment agreements, no restrictive covenants at all. No solicitation, no non-solicitation covenants, no non-competition agreements. There was no voting control that could be afforded by selling Dr. OPYOKE's 50% unwashed interest, and there were no protective agreements to protect the Urgent Care Center. The two doctors were also, in addition to their operational responsibilities, were personally liable on the location leases. There were, in fact, two locations. Those leases had personal guarantees, and they were personally guaranteed by the doctors. If Dr. OPYOKE is going to sell his interest, obviously someone's going to have to replace that guarantee. No effort was made to show how that was going to happen or to factor that in, according to Mr. Lewis's testimony. In addition, there was a commercial line of credit. $750,000 line of credit from PNC. At the time of the case, it was $625,000 outstanding. The next test was the fair market value. Judge Sasso, you're correct. I believe that Thompson and its progeny require the court to assess the fair market value. Mr. Lewis at trial said there's no real-world analysis that will allow this interest, this 50% unspecified interest in Suncoast Urgent Cares to be sold because there's no restrictive covenant. And then he tried to distinguish between some hypothetical or artificial world that he read into the Held case and the real world. We reject that distinction that Mr. Lewis was trying to make to the extent that I can even understand it. But the entire positive cash flow we showed would be wiped out if the occupational medicine practice were to walk out the door. So when we originally took this case on, we too thought an urgent care center is an urgent care. It's next to Publix, it has a green sign, it is open convenient hours, and location, location, location. But when we delved into it, we realized that a significant portion of the practice has to do with the occupational health. There's a workers' compensation piece, and there is the employer-paid services, physicals, drug screens, all those kinds of things. And we went out and got the customers, the clients, if you will, of the urgent care center. We got somebody from the county who had sent their people beyond many other locations to this particular location because Dr. OPYOKE and Dr. Dewick had separate specifications, separate credentials to deal with this occupational health. The fire department was the same way, Walmart distribution was the same way, and the Walmart guy says, I even recommended it to Walmart Transportation, two separate divisions within Walmart, that they would go past other locations to go to this location because of the relationship with Dr. OPYOKE. Dr. OPYOKE, Dr. Dewick, and their finder, if you will, their independent contractor who did the marketing, Mr. Mays. Mr. Manny makes an issue and had a trial about the fact that there was some purported transfer of goodwill. Not so. That's not the analysis that Mr. Tondreau used. It's not the analysis that the trial judge used. The analysis was that both accountants agreed that as is, the company generates normalized net cash flow of $510,000. With some adjustments, that would be reduced to approximately $417,000, but let's use the $500,000 number. Before adjustments, then the income that was attributable to the occupational medicine piece of it was $628,000 before you take off those expenses that you can save, those variable expenses, gauze pads, medicines, other things that you can save. And we asked Mr. Tondreau and Dr. Dewick, can you save money by eliminating the occupational health piece of this practice, by eliminating staff, by eliminating office hours, by eliminating other large ticket items? And the answer was no, that you couldn't do that because you had to be available for those walk-in patients. That's the nature of the urgent care. So he took and reduced the $628,000 of cash flow by an adjustment for those variable expenses on the rest of the practice, and he figured that was 13.6%. So he took the $628,000 of net cash flow attributable just to the occupational health, reduced it by 13.6%, and still it was well in excess of the overall cash flow that was generated from the business of 510 or 417 with adjustments. And as a result, there was no net cash flow available to capitalize at 4.83 or any other capitalization figure to arrive at a net income analysis for fair market value. So the experts went to the market, to the real life market. And they went to that market and assessed what would some independent buyer, not under duress, fully informed about the situation, be willing to pay for Dr. OPYOKE's interest in the business. And they determined it's not saleable. And I asked Mr. Lewis that question 4 different ways, and I got the same roundabout answer that essentially says, not what Mr. Manny just represented to the court, but it's just not going to be saleable, says Mr. Lewis. I understand that it's a problem, but I'm going to make a distinction between real world and artificial world, and I think we're bound by Held to do something that is not real world, that makes no sense, that's not logical, just because Held says that. I've read Held at least 30 times, and I don't see that Held requires this court or anybody else to adopt an artificial standard by which to evaluate whether the interest is marketable, and if it's marketable, what it would be. The Tondreau methodology was to remove the revenue attributable to the occupational medicine as a means by which to address the personal goodwill, because we created this collage of effort to show that the profitability of this business was based upon the occupational medicine piece. And that's what Mr. Tondreau was referring to when he says it's a strange situation. I have only one piece, and it wasn't 12%, it was 17%, but so it's a small piece of it, we acknowledge that could effectively turn the capitalized income approach to a negative number.
Well, let's say this court found that the approach used in determining the value of the personal goodwill was not based on competent substantial evidence. Maybe the approach was error. Could this court then infer that that value was enterprise goodwill, or would there have needed to be separate testimony as to enterprise?
That's an excellent point, because I think the error has to be independent evidence of what the enterprise goodwill would be.
And the law requires that that be based on a fair market value approach, which both experts specifically say they rejected in this case due to the lack of data.
Both of the experts rejected that analysis because there was no way to determine the enterprise goodwill, because there was insufficient income, overall income, that could be capitalized using that approach. And when you add to that analysis all of the debt that would have to be assumed by the purchaser, which was never addressed by Mr. Lewis in any way, shape, or form, that's the lease guarantee and the promissory note. In addition to that somebody's going to come in and not have any control whether Dr. Dewick stays or leaves, and instead what they did was just try and put the onus on to Mr. Tondreau or on Dr. OPYOKE to demonstrate that there in fact was personal goodwill that could be excluded from an overall valuation. That's backwards. They have to demonstrate that there was in fact enterprise goodwill that exceeded the hard assets. And in this case, that analysis that takes you negative, so you wouldn't evaluate the marketability, or the market value, I should say, based upon what happens with the income, because it's not, you can't buy it. It wouldn't be purchasable.
Mr. Solomon, in light of the Walton case and the fact that we don't have a non-compete agreement in this case, isn't it virtually impossible in this case, with the absence of the non-compete agreement, to establish enterprise goodwill?
You know, I think that's what the cases say, but I, in my mind's eye, could imagine that there might be certain situations, such as a retiring doctor, where there wouldn't be a covenant not to compete, but he's going to leave the practice, or a doctor whose interest is being sold because he is not practicing for some other reason. He's ill, or he is not able to practice. So I could imagine that it's not such a broad brush.
But in this case, you have actually evidence or speculation that in fact, not just one of the three people involved in this business, but perhaps all three of them could change their location and feasibly hook back up again and form another business, which would virtually make it valueless, correct?
Absolutely. They could move across the street, and because of the unique relationship, maybe not so unique, but a near 20-year relationship between the two doctors, without any other operating agreements, they trust each other explicitly and implicitly, and they have a guy who goes out and whose business is to evaluate those employers in the area and bring them to the table. All of them, without hesitation, said, we're a team, and we'd go across the street. If Dr. OPYOKE were to move across the street or down the block, we'd go with him. And even to the point where at least one, and I think maybe two, of the third parties that we brought in said, if he were to move, we would go follow him wherever he went, subject to how far away it is. If he would move way far away, presumably they would be reevaluating whether they would send their employees, because it takes them time.
But that would also seem to fly in the face of, with an urgent care practice facility, there are people coming into that facility because they require urgent care, and it doesn't matter. I mean, they're basically taking their chances as far as who is in there to provide the care because they need the medical services. That would seem to me that you are then totally eliminating any value of the business with regard to that portion of what would appear to be enterprise goodwill.
That's true.
So you think that's totally zero as well?
I think that there would be, under the operations of this company, if the occupational medicine would leave, the only thing that would be left would be the tangible assets, the FF&E, the fixtures, furnishings, and equipment that had a value of $106,000. That's the only thing that would be left to capitalize under the circumstances. There would be no doctors, they would have tangible assets, but the income that they generate, which was what was unique and unusual, according to Mr. Tondreau, was that it's really the occupational medicine that drives the profit. Nothing else makes a money out of it. And there wouldn't be anything to make money from under the capitalization of income approach. I could repeat what I said, but I don't think I have anything more to add. Unless the court has some questions, I appreciate your time.
Thank you. And you have about 4 minutes left.
Thank you, Your Honor. I'd like to read, if I may, a portion of the transcript to explain, I think, my position more clearly. Step one is find out if there's any value to the business. That's the fair market value approach that's dictated by the Thompson case. Step two, if there is any fair market value of the business, the next thing you do is you determine whether or not there's a difference between the net asset value and the fair market value of the business. That was done in this case. We now know that the difference between the net asset value of the business, and we know what the net assets are anyhow of the business, $103,000. Well, then the next step is, predicted directly by the Thompson case, which was not done in this case, is valuation of the personal goodwill. And my question was, here's at transcript 1092, did you make any attempt to calculate the value of the personal goodwill alone of Dr. OPYOKE in this business? Answer, no, because I don't know what the personal goodwill components would be for Dr. Duick. That's the shareholder of the husband, the LLC, in which they did business together. Now, I continue that answer, that questioning, to try to get him to tell us what he was doing in the case. And he says, now, it's strange you should ask that question because there was a comment made in the testimony. Dudley said he could support, Dudley is Mr. Mays, the contractor. He could give his full support for he would support and give his full support for Dr. OPYOKE. Dr. Duick answered a question on the stand. What would you do? And he said, well, first of all, I don't want another partner or a different partner. I would also even go with Dr. OPYOKE. The next answer is, I'm answering your question of what happened to the goodwill. The goodwill has all been transferred to the state by the statement of these other two people to Dr. OPYOKE. Now, that does not support the proposition that there's no enterprise goodwill. That does not support what this trial judge did here. We now have introduced a new concept, a transfer of goodwill, because the partner said that I want to go with him if he goes. That was a misstated predicate. The predicate in this case is, if in fact you want to determine whether or not there is personal goodwill, you can ask the question, what would happen if he left? That's purely a hypothetical question, but it assumes the continuation of the business, and the fair market value of the business remains the same, doesn't change for these purposes. We then try to identify and value the personal goodwill. That's what was at issue in this case, and that was not done. The trial judge clearly erred. Thank you.
Thank you. Thank you for your arguments, and we are in recess.